Welcome to Hull on Estate and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana Popovic-Montag that will provide information and insights into estate planning in Canada from the offices of Hull Estate Mediation in Toronto. Here are Ian and Suzana.
Hi, and welcome to Hull on Estate and Succession Planning. You're listening to episode 129 of our podcast on Tuesday, September 9th, 2008.
Hi, Suzana.
Hello, Ian.
So we've swiftly moved out of the summer into the early fall. And we're going to continue to work through this will challenge discussion and the process itself. In our last podcast, we talked about the concept of when we will go to discoveries and when we'll go to mediation. What mediation is, what are discoveries. And working from our flows chart, I think it's worth emphasizing the intense investigation stage is so crucial. If we can get a good flow of information from obtaining a good, broadly comprehensive order for directions, and we can get the three corners of a lawsuit and a will challenge, or get the lawyer's notes, assess it, analyze it, depending on whether you're defending or challenging the will. The second part, the medicals, get as much of the medicals as possible. And the third component, chase down the lay witness evidence, chase down the witnesses, what the neighbors and friends and priests and so forth are going to say. So if you can do that, and you can really, this is a bit of a heavy loaded stage in the lawsuit, okay? This intense investigation is where this branches out into really settlement, all-out war, how we're going to manipulate the process in that sense. And that's why it is such an important question is, do you go to mediation or do you go to discoveries? The right cases, you go to discoveries or depositions right away, because what has come out of this intense investigation are really good questions that you want to explore. And an easy example is when your case is very light on medical evidence and lawyer's notes. The lawyers are saying, yeah, you say you're challenging. The lawyer's saying, yeah, the deceased knew what he was doing. And the medical evidence is light because the deceased, although you think was completely out of it, wasn't someone who went to doctors and just historically didn't have that kind of a record, the third-party record. But the third-party witnesses, friends and neighbors and who they went to church with and those kinds of things, you're really confident in challenging this will all support you. So one of the tactical moves you might consider then is to go to discoveries in a situation like that where you need to really develop your case. Because there's two ways you develop your case. One, through third-party evidence, which I've talked about doctors and lawyers, and they kind of fall into place. And two is from others and yourself.
Now maybe, Ian, you could just spend a moment and explain to us why a discovery process is different, or what additional information you could try to get from lay witnesses from just perhaps interviewing these individuals that you're suggesting.
Well, I think it's a good point, and I'm not sure I can. I mean, I think the interview process is probably as comprehensive as I need. What I'm thinking of is that when I move from the intense investigation and I decide to go to discoveries, it's because I need to take a real run at the challenger or the propounder. And I have a whole pocket full of evidence in contradiction to their position. So that maybe I rattle the challenger or maybe I don't. But I'll have taken that active step to really do a bit of a strategic shakedown.
And from a lawyer's perspective, one of the things that discoveries really helps us with, whether we're discovering the other side or our client is being discovered, is assessing how that individual is going to act as a witness in the actual trial. And there's a lot of value that can come out of this whole process if you can see how your person stands up under the bright lights of the camera, so to speak.
That's good. So keeping in the bright lights, my personal view is discoveries is a low percentage game in most cases. But we didn't want to sort of gloss over it. We don't want to sort of pretend that this can be ignored and should be ignored. It is an important either tactical or evidentiary stage in the process in the right case. But if you want to come back to what is, I think, the more effective practice, that is get to mediation as soon as possible. Because these cases are more often about emotions than they are about definitive facts. And as we've said before in podcasts, we're never going to know the answer, the true answer. And mediation offers us such a tremendous cost-effective way to get to the nub of the case quickly and efficiently. But let's keep on with the process, because presume we don't pull it off. We don't settle this case, or the discoveries bring out great new evidence that is going to affect this case, and we're going to keep moving forward. The next stage, certainly in Ontario, it's required, and almost every jurisdiction that certainly I've ever been involved with insists on it, is a pretrial.
And what a pretrial is an actual meeting where the parties meet with a judge, a pretrial judge, who's going to maybe once again try to settle this matter. Not quite as in the mediation format, but certainly in that kind of an structure without as much formality as you would have at a trial. So this individual is going to hear the parties, he's going to read briefs that are presented, he's going to meet the individuals, and then assess the likelihood that one side or the other is going to win.
So this pretrial judge is, the importance of this is that you're often looking to that person to give you their gut call. Now, they won't have had a chance to hear all of the evidence, but they'll have read the brief, they'll understand the case, they'll have their own experience because they've sat on the bench and they practice law and now are sitting on the bench. They have their own experience in terms of likelihood of success. And it can be really effective if we've got a good interaction with a judge that's prepared to give, sort of their views in that regard.
And the pretrial process really underscores how important the system itself believes that the parties try to settle their own case. Because in a will challenge, we know, Ian, that when it gets to trial, there's going to be one winner and one loser. And at the end of the day, with cost consequences factor in there, we even wonder if the winner is in fact a winner. So the fact that there's this requirement for a pretrial, and in many jurisdictions also a requirement for mandatory mediation, makes us realize that this probably is the best way to try to solve the matter, if in fact it can be. If not, then of course we can move on to the next stage.
And the next two stages we're going to talk about fairly briefly today, because one of them in and of itself probably is its own podcast. The next stage, of course, is if you don't settle it, is you go to trial, where you get your day or days, typically in court, in front of a judge. In Ontario, they're typically in front of just a judge. We don't have juries with will challenge cases. The statute actually essentially prohibits it. But in lots of jurisdictions, there's also will challenges with juries itself. So we have the trial itself, where we get witness in the witnesses' boxes and doing all of the things that are normally done on the typical Law and Order kind of style trial. So there's no magic to the trial itself, but we're going to talk in another podcast about how we get ready for trials for two reasons. One is that it's helpful to talk about what you have to do, but secondly, get another sense of something that is overriding this whole thing, and that is the big, terrible word called costs. And the costs of all of this process can't be ignored. So the trial obviously we're into having created tremendous costs and tremendous costs to complete. So the last stage.
And I think just to end on that, Ian, the last stage is the appeal process. Because even though you've gone through the trial, you've incurred these tremendous costs that Ian just mentioned, there's no guarantee that that's the end of the process, because the losing side can always have the option of choosing to appeal. And here in Ontario, there's two levels of appeal, and you can appeal to the divisional court. Sometimes you're required to appeal directly to the Court of Appeal. And then, of course, if the matter is appealed, it's heard, and that result is not liked, the ultimate remedy is to appeal to the Supreme Court of Canada.
All of which is delay, costs, all of the really difficult things that you have to suffer through with litigation. But let's end on a happy note. That's the process, and we like to go through those with our clients so people know from start to finish generally what is going to happen. So thanks very much, Suzana.
Thanks to you too, Ian.
You've been listening to Hull on Estate and Succession Planning with Ian Hull and Suzana Popovic-Montag. The podcast you've been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other Hull On podcasts or to leave any questions or comments, please visit our website at hullestatemediation.com.